Where we dive into the unfolding political drama in Rivers State. President Bola Tinubu had declared a state of emergency in the Oil-rich region, suspending Governor Fubara, his deputy, and the entire state assembly, while appointing a sole administrator to take charge. We are joined today by a distinguished guest, Inibehe Effiong, a renowned human rights activist and lawyer, to unpack this and what this means for the future of governance in our nation. Welcome, Mr. Inibehe Effiong. Welcome to Star TV.
Thank you. Thank you for having me.
So let's just dive into the topic of today. Everybody has been talking about the Section 305 of the Constitution, which gave the president the power to suspend now whether the governor of a state or other political appointees. What exactly does this section speak to suspension of a governor by the president?
Thank you. Well, let me start by correcting the position you have put forward. The provisions of Section 305 of the 1999 Constitution of the Federal Republic of Nigeria as amended does not give the President of Nigeria the power to suspend a governor, deputy governor, or a House of Assembly. All that Section 305 does or enables is that the President is given the constitutional authority to declare a state of emergency throughout the Federation or any part thereof. That is, a state of emergency can be declared all over Nigeria or in some parts of Nigeria. It can be in some local governments, can be in one local government, it can be throughout a state, it can be in 5 states, depending on the peculiarity of the situation, depending on the facts giving rise to the proclamation of a state of emergency. Now, the framers of our Constitution understood that circumstances may arise where there is need to take extraordinary and fundamental measures for the purpose of ensuring that governance continues and that there is no disruption in the constitutional structure that has been put in place. That is the basis for which the Constitution allows for the proclamation of a state of emergency. Now, going to the specifics, because we need to break this down for people to really understand what is at stake here. For a state of emergency to be declared, okay, the Constitution is express on what has to happen, what must be present for that power to be exercisable. Yes, this power is given to the president, but when is it exercisable? How is it exercisable? Okay, now when is it exercisable? If you look at Section 305 sub 3, the Constitution says the state of emergency may be declared, as I earlier explained, either throughout the Federation or in a component part of the Federation. One, where the Federation is at war. When Nigeria is at war, a state of emergency can be declared. 2, where there is an invasion, the country is being invaded by foreign adversaries. Okay, assuming there is a diplomatic dispute or crisis between Nigeria and the Niger Republic, or between Nigeria and Cameroon over one issue or the other, and then either of these countries decide to invade Nigeria, the president can declare a state of emergency in order to address to that emergency. For you to declare a state of emergency, there has to be an emergency. You do not declare a state of emergency over a matter that is stalled, over a matter that is not expedient. Now, the other circumstances permissible under Section 305 is where there is where natural disaster occurs or has taken place. And that natural disaster has to be one that is so prevalent, so extensive, that, as I said, extraordinary measures are required immediately to address it. The fourth instance where state of emergency can be declared is where there is a total breakdown of law and order. Complete anarchy has ensued. The president is allowed to declare a state of emergency in the territory or the areas impacted by the breakdown of law and order. The other fifth, that should be number 5, the fifth instance where a state of emergency may be declared is where there is likelihood, imminency of breakdown of law and order. That is, it is so imminent that if urgent steps are not taken, then there could be monumental loss of lives and destruction of public properties. These are the circumstances under which a state of emergency may be declared. So you don't declare a state of emergency as a matter of convenience. You don't declare a state of emergency to address political disputes or altercation between organs of government, okay, because the legislature and the executive are fighting, right, are not communicating properly. You now say you want to declare a state of emergency. If there is a dispute in a state, as we have in Rivers State, between the executive, Mr. Fubara, and the House of Assembly as we have now, and it is such that their capacity to discharge their responsibility is impacted, that is not sufficient for the president to exercise the power of declaration of the state of emergency. But assuming that the president in his wisdom still feels that there is need to proclaim a state of emergency because the organs of government in the federation or a state are unable to discharge their responsibilities, then what is the incidence of the emergency? What is supposed to happen? Again, as I said, the purpose of declaring a state of emergency is to give room for an immediate extraordinary measures to be taken in order to address the issues that gave rise to the emergency. So there is nothing in section 305, nothing remotely that is suggestive of suspending or removing elected officers or elected persons such as the governor, deputy governor, or members of the House of Assembly.
So the president, while giving the speech yesterday, made reference to the vandalization of pipeline, and which he said could lead to breakdown of law and order in the state. Isn't this sufficient enough to declare a state of emergency?
Well, I think the president is being mischievous on that point, because if you want to declare a state of emergency because of pipeline vandalization, vandalization of pipeline is something that we have witnessed in the Niger Delta over the years. Okay, we have seen this year after year. It was until after the late President Yar'Adua introduced amnesty to the Niger Delta militants in quote that we saw a drastic reduction in militancy, hostility, and armed struggle in the Niger Delta. So if you are now going to declare a state of emergency because of pipeline vandalization, that is itself trivializing a serious matter. That is a way of making a mockery of the Constitution, because it will mean that any state where the pipeline is vandalized or public property is vandalized, the governor has to be removed, the deputy governor has to be removed, the members of the House of Assembly have to be suspended. So that will mean that most of the states in Nigeria today, the state of emergency should have been declared. And then the governors of those states, their deputies and the House of Assembly should have been suspended as well. So you don't declare a state of emergency because of an isolated, right, attack on public facility. No. And assuming that you even need a state of emergency to address a pipeline that has already been vandalized, because there has to be something has to be emergent, urgent, extremely urgent. If you want to declare a state of emergency because of pipeline vandalization, it will mean that in many states of the north today, the northern part of the country, where we are seeing terrorists killing people like states of Benue, Plateau, and so on, people are being slaughtered by so-called bandits, state of emergency should have been declared in those states, including on those states where, as I'm talking to you, protest is taking place because so-called armed herdsmen are killing people. Why has state of emergency not been declared in those states? So you don't declare state of emergency because of specific or isolated security breaches. That itself is an indictment on the president. If the president declared the state of emergency in Rivers State because of the attack on the pipeline, the blowing up of the pipeline, the president himself is admitting to his incompetence as the commander-in-chief. He has not queried the chief of naval staff. He has not suspended the chief of naval staff. He has not queried or suspended the inspector general of police, the chief of defense staff, the chief of army staff, the chief of air staff. All the service chiefs are still in their offices. These are the persons that have the constitutional responsibility to safeguard all installations and all facilities. And there is no indication that anybody within the law enforcement institutions of our country have been penalized. So you are now saying that a pipeline that you have not established is caused by the governor that was vandalized. You are not you are not punishing the governor for it. Is the governor supposed to have stood by the pipeline with AK-47 to safeguard it? The president is just giving a ridiculous reason. This is not a basis to declare a state of emergency. The question of removal does not even arise because the constitution itself is clear on the tenure of office of a governor and when a governor can cease to hold office.
The Nigeria Bar Association has described this as an executive overreach, and one of the reasons put forward is that there is a pending case at the Supreme Court that is all about addressing the political differences in the state. Do you also align with this, that the president should have continued to seek resolving the political differences rather than suspension of the government?
No, the president cannot be they want to give interpretation to the judgment of the Supreme Court in the manner that he has done. Let's even assume for a second, as the president insinuated in his address to the nation, that Fubara has failed to adhere or comply with the judgments and the orders made by the Supreme Court. What is the way to address it? The Constitution is not silent. Of course, under Section 287, on enforcement of decisions, the decisions of the Supreme Court is binding on all authorities and persons throughout the Federal Republic of Nigeria, including on Tinubu, Fubara, and the rest. But if the judgment of the Supreme Court has been violated, what you do is that you go back to the Supreme Court to enforce it. There are mechanisms under the law for enforcing the judgment of the Supreme Court. And the fact or the allegation of constitutional violation against Fubara is one that the Supreme Court has itself already addressed by even saying that the allocation of the state should be withheld. That itself is punitive. But you are aware that Fubara had, in compliance with the judgment of the Supreme Court, the local government's leadership in the state, all the entire local government chairmen and the rest, they were dissolved. They have vacated their offices. In compliance with the judgment of the Supreme Court, he has recognized the Amawele-led House of Assembly. And in furtherance of that recognition, he wrote 2 letters to them seeking to present budgets before the House. Suddenly, they said they are going on indefinite leave. So, what you are seeing is an act of political desperation by the president. Tinubu is punishing Rivers people because they refused to vote him in the last general election, in the 2023 election. Everybody knows that APC lost Rivers State. The results that were declared were diabolical results concocted in the bedroom of some criminals who just sat down and wrote results. Independent review has shown that Labour Party won the presidential election in Rivers State. There is not, this is so clear. The APC did not win that election. So I believe that what Tinubu is doing here is basically preparing for 2027. I don't see this decision that he has taken as a decision taken to restore law and order, because he himself is a principal culprit in the exacerbation of the crisis in Rivers State. Okay? And let me also further state that by virtue of Section 180, and also look at 181 and 189 of the Constitution, the tenure of office of a governor is clear. A governor must remain in office. The only circumstance under which a governor can cease to hold office is if, by reason of death, Number 2, resignation. Number 3, permanent incapacitation. That is on grounds of medical incapacitation. The governor is sick or in a state of permanent coma or has stroke that is not recoverable, and he can no longer discharge his responsibilities. In which case, the State Executive Council can meet and pass a resolution after a medical board has been set up to determine that the governor can no longer discharge his responsibilities because he's permanently incapacitated. They can pass a resolution removing the governor from office. Or by impeachment, pursuant to Section 188. Those are the circumstances under which a governor can cease to hold office, or a governor may vacate his office. None of this has taken place. So, in law, we have a principle called expressio unius is exclusive alterius, which simply means that the express mention of one thing is exclusion of others. The Constitution has expressly mentioned circumstances under which a governor can cease to hold office, whether temporarily or permanently. And the state of emergency is not one of them. Furthermore, regarding the dissolution or purported suspension of the House of Assembly for 6 months, if the thinking of Tinubu is that the House is unable or can no longer discharge its constitutional responsibility under Section 4 of the Constitution of making laws for the state, for the good peace and order of the state, the Constitution itself has also provided a solution on what should happen. And that is in Section 11, that says that where the Federation is at war, or where a House of Assembly is unable to perform its responsibilities as a House, that is, it can no longer sit. In fact, Section 11 has defined the circumstance, what it means for a House of Assembly to be incapable of discharging its function. He says when it can no longer sit to carry out its legislative functions, what is supposed to happen? Section 11 says the National Assembly shall temporarily assume the legislative functions of the state and make laws for the state. You get it? So whether you are looking at situations where the House can no longer perform its functions, assuming that is what Tinubu is saying in the case of Rivers, it does not lie in the mouth of Tinubu to call the NTA or call journalists and carry a wordless piece of paper and purport to remove the members of the House of Assembly and purport to, remove them for 6 months or suspend them for 6 months. It is supposed to be the responsibility of the National Assembly. Okay? And regarding Fubara, if Fubara has violated the Constitution, is a grave violation of the Constitution, that is an impeachable offense under Section 188. Gross violation of the Constitution is one of the indices of gross misconduct. If you look at the way gross misconduct is defined, a grave violation of the Constitution is one of them. So if they are saying that Fubara has gravely violated the Constitution or has gravely disobeyed the Supreme Court, there is the option of impeachment under Section 188. So there is nothing that is not addressable under the Constitution. But to say that a governor that was elected and affirmed by the Supreme Court said Fubara was duly elected, to now say that that person, the head of a federating unit, can be removed by the president, the head of the federal government can remove the head of a state in the name of suspension. It is a constitutional aberration. And to even say that the president can purport to appoint sole administrator, it is laughable, it is disgraceful, it is abominable, it is dubious that this kind of argument can even, that this aberration is even being put forward. What does sole administrator mean? This is a terminology, this is a phrase whose origin is traceable to military rule in Nigeria. And that is why it is not surprising that it is Rear Admiral Alibo Ete retired, okay, that is appointed as the so-called sole administrator. The reason why is the sole administrator from when Obasanjo started this impunity of conditionally removing elected government in the name of emergency, the reason why they have always appointed military people as sole administrator is because that is what used to happen under the military. So, Tinubu government arrested protesters during the end bad governance protest because, according to them, they were carrying Russian flags and calling on the military to take over. But by his action in Rivers State, Tinubu has invited the military to take over the governance of Rivers State. That is what he has done. Tinubu has handed over the governance of a state in Nigeria to the Nigerian military. So what has happened is a presidential coup staged in Aso Rock against the government and people of Rivers State. There is no other way to describe it. There is no other way to describe it. General Igbo is unknown to the Constitution. The position of sole administrator is unknown to the Constitution. It is an aberration. What does it mean to administer a state solely? Because solely or sole means alone. Okay? And imagine Tinubu saying he shall not make new laws. That anything relating to laws, but he cannot ever issue regulations or guidelines for the governance of the state, submit it to the president, who will now table it before the Federal Executive Council. When did Federal Executive Council become a legislative body? When did it become the mandate of a Federal Executive Council to make laws for a state? That you will now say that the sole administrator should sit somewhere and put a pen to paper purporting to be issuing regulations or laws for the state, send it to you in Abuja, and you convene your minister to make laws for Rivers State. Not the National Assembly empowered under Section 11. Not the House of Assembly empowered under Section 4. The Federal Executive Council, ministers who are appointed to serve the president, federal ministers, because ministers are equivalent of commissioners. And the Federal Executive Council consists of the president, the vice president, the SGF, and ministers, and possibly chief of staff to the president and other top government functionaries. The Federal Executive Council is Federal Executive Council. It is not State Executive Council. It is not State Legislative Council. So there is no constitutional interpretation that can permit this. It simply doesn't make sense to me. And then you are even saying that the governor should no longer perform his responsibilities. The House of Assembly should no longer perform his responsibilities. All the reasons that Tinubu have advanced are untenable. I am not saying you cannot declare state of emergency in Rivers State. I am saying that there is no circumstance that has warranted it. And assuming there is, that does not empower you to remove a duly elected governor whose tenure is 4 years, whose oath of office subsists for 4 years. Because while the oath of office of the governor is still subsisting, okay, you cannot truncate the exercise or performance of his constitutional responsibilities. So what Tinubu is saying is that he has not only suspended Fubara from office, he has also suspended his oath of office. The oath of office cannot be valid. And then the gubernatorial or executive powers of the governor is in suspension or in abeyance. It is impossible. It is impossible. So, and then you are now saying that you have abrogated his tenure from 4 years and subtracted 6 months from his tenure. And the constitution says a governor shall remain in office for 4 years. Remember the case of Peter Obi that went up to the Supreme Court on the tenure of office of governor. The Supreme Court said it is like you cannot shift it. A governor must remain in office for 4 years. The only circumstance under which that 4 years can be altered by 1 day or by 1 hour. You see, the governor dies, the governor is impeached, the governor is incapacitated as found by the medical panel, and the State Executive Council of the state make that determination, or the governor is impeached. Where none of this has taken place, you cannot violate the tenure of office of a governor or president by 1 day, let alone for 6 months. Let alone for 6 months. And the so-called sole administrator, what is he going to do? Will he now sign memos for payment of salaries? Can he make appointments? Because Tinubu said he should not make law. But can he make appointments? Can he effect changes in state parastatals? Like the Rivers State Independent Electoral Commission, for example. Okay? Can he change the head of the Rivers State Board of Internal Revenue? What is he supposed to do? Because these are powers that under the law, the relevant laws of Rivers State, are exclusive to the governor of the state. Only the governor can conditionally exercise those powers. So when you are saying you are appointing a sole administrator, are you now substituting a governor as stated and mentioned in the laws of Rivers State with a sole administrator? That is why those who are supporting the president, they are unpatriotic people. They are people that want to set Nigeria on fire. And it is shameful that Tinubu, who had publicly deprecated, excoriated, President Jonathan and Obasanjo for declaring state of emergency. In Obasanjo's case, go and check, it has been shown, the evidence has come out. Tinubu said he had no power to remove the governor of Plateau State. Today, Tinubu is doing exactly the same thing. So you can now see that this is political vendetta against the people of Rivers State on account of their decision not to vote the Milokon ideology in 2023. That is what has happened. Nigerians should not mistake this as a president who wants to obey the constitution or want to restore constitutional order. That is not what it is.